back. Let's do this. You know what it is? Based on the facts and the facts only. So basically, we're gonna go back at this. See that? We're gonna go back at this. And it's even got the date of 2005. Alright? So basically this was in effect when that situation went down. And the key thing is, I had an individual come at me on my YouTube page, and he's barking, he must have been a student. You don't know this, you don't know that. He's trying to argue the fact of basically, and I just showed you the key thing. He's trying to argue the fact in law, you have two separate sizes. You have what you call the public side, and you have which is the natural living man or woman side. You can't say person because person is a corporation. All right. So he basically was trying to come in. Oh, you don't know what you're talking about. You don't know about the public. Blah 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 blah. And I'm like, dude, let's go there. One, you don't recognize the fact that I was a law enforcement officer for the city of New York for more than 3 entities, or for at least 3 entities. That's one. Two, the fact of the public is when you work in the public governmental administration. All right, that's the public. You have you took an oath. You're in the public, baby. You're working in the public. Now the private is when you, the person, the natural living person, is affected by someone in the public's actions. So the key fact that he was trying to beef about subsection 242, deprivation of a right under color of law, and then subsection 42, deprivation of a right or privilege, that would be as you as a person. As you as a natural living man or woman. How they deprived you. The right is, a living right. You can't even say God because God is in the public. It's basically government. Yeah, look it up. So you got to say natural living, natural living man or woman. All right, even child. Now, he was beefing, trying to say like, well, how did they get you in the public? Well, let's go there. When you're working in the public, in the whole 9 yards, as the employer, let's go with that probationary hospital police assistant deputy director did back in 2008, July 17th, where he used the vehicle in a reckless endangerment manner. That would be pretty much the first one that locks in. We'll toss the other little ones out the way. But when you use the vehicle, the key thing in using a vehicle, you broke the traffic law. It's a motor vehicle, you're violating the traffic law. Traffic law would be subsection 1212, New York State traffic law. Reckless driving. The actions was intentional, placing a person in fear of imminent danger or immediate danger. By stumping on the brake, yeah, I scared you. Yeah, but you broke a law. Now, along with that, you would get subsection 2020 of the penal law. Okay, this is a penal deal. Now it's criminal. It's a criminal case. It's past the traffic. Traffic is not pretty much criminal unless certain things are kicked in. Okay, the fact that you was a public servant, 19500. You work for a public employer, subsection 2025 as an employee or supervisor, director, assistant, deputy director of that employer. Okay? Now, the mere fact that we're going to move on, we're going to go to the fact that it was reported to supervision, the 2 tour commanders, and they gave the nod. Not just the nod, they gave the directive. Respond up to EEO, facilities EEO, because according to the employer's guidelines, all you have to do is talk to a supervisor and then a member of management. He's a member of management. So you go to I went to the EEO, like they said, And the EEO took the complaint. Now, the key fact about them is when taking a complaint, you use the New York City's equal employment opportunities policy. They can take it verbally or they can take it written. It's up to them to document it. Okay, they have to document it. Now, we're going to go with the key fact here. All right, and after doing so, when the officer went outside and filed outside because they was delaying the process, once he goes outside, because it says right here, other places where the complaint may be filed. The following federal, state, and local agencies enforce laws against discrimination. The New York City Commission on Human Rights and New York State Division of Human Rights. The United States Equal Employment Opportunities Commission, the EEOC, or the Department of Justice. Boom. Okay? Information about how to contact these agencies can be found in the EEO's policy handbook. It can be found in the city's book. And it's highlighted so that, even if you go online, like this is, you tap that, it goes right directly to their pages. Now, basically, that's telling you what you can do when you don't want to deal with your agency. Now, when you go to one of these agencies, so say you got to go to the locals first, and that would be the city, New York City's Commission of Human Rights, on Human Rights, or the state, New York State's Division of Human Rights. Those are the two locals. You have to go to one of those first. When you go to that, either entity, the case is automatically transferred to the other entities so that you don't have to go to them. So they basically share the information, allegedly. Okay? So that's why they guidelines. Hold them accountable by their guidelines. It's written on a document. A document is a contract. Anything written is a contract. You hold them accountable to that contract. Now, we're going to go to this other part right here where the individual didn't understand. Because it says here, when a person exercises his or her right to file a complaint with a federal, state, or local administration agency known as external complaint based on or related to the same facts and circumstances of the internal complaint. Got that? So the agency EEO will transfer the matter to the agency's general counsel. So that facility's EEO, once you got the once the officer went outside, you don't send off a rebuttal. You transfer it to the general counsel. And the general counsel takes it from there. But you was working the magic. Not a problem. Not a problem. That right there shows you deceptive practices. It's saying, who will be responsible for any further handling of the matter? The EEO officer who will notify the complainant and the parties who are the subject of the complaint in writing. So when it's in writing, that's a contract. Right? That the investigation by the EEO officer has been transferred because of the filing of an external complaint. So once the external complaint was filed, it has to be transferred. All right? And she has to notify everybody. The agency general counsel will be responsible for handling external complaints, regardless of the times of such complaint, whether filed before the internal complaint is filed at the same time that the internal complaint was filed, or after the internal complaint was filed, but prior to the complaint, the completion of the agency's internal EEO. Let's go to the next page. Procedure. The transfer of the complaint to the agency's general counsel office should in no way preclude that the EEO officer from cooperating with the general counsel office with respects to the ultimate resolution of this complaint. You got to use what they use against you back against them and hold them accountable under the oath of office. You're a city employee. You took an oath to get that job. How you got a transfer and you didn't follow your policies and procedures is a wonder to me. Like I said, that keeps the door open. That keeps the door open. See, the key thing is once that was filed, that fraudulent case of going to 40 Rector would have been shut down because it was supposed to have been shut down from the beginning. From the beginning, what you was trying to do was, well, we're gonna get him out before that could come up. Not a problem. You got procedures here. Not a problem. We're gonna hold you to these procedures. We're gonna hold you to that. We're not gonna go anywhere else. We're gonna go by what's in the signed contract agreement. It's the only thing. But I understand this is a normal thing you've been doing to people for quite some time. Oh, they don't read. They don't read with understanding. Oh, you ain't go to no law school. I was a law enforcement officer. Yeah. How hard do you really think it is to learn law if you're already a law enforcement officer? You don't fill out documents and put false information on there. Because you do, that's a lockup. That's just not a termination. That's a lockup. Abuse of authority. You do know what 19500 is, right? That's to the public servants. Now back to this, to under Title 18. Let's go back to Title 18, okay? Under Title 18, it basically says the law enforcement officers, right? Let's come out of this. It basically says the law enforcement officers, and it says the bingo. Okay, this is something else. It basically says the law enforcement officers and public employees, if they violated their how would you say, on the color of law, if they violate their policies and procedures and even laws under color of law. Remember, color of law is basically fraud. It's fake. It's color. It looks good. It's not good. It looks good. You know, you got to have an actual fact. You don't have an actual fact, you can't. Well, I'm just gonna do this. No. Because behind that comes in constitutional law. And say, what was your grounds? Because when you're using color of law, you're using your authority, you're using your actions, but you have to have principle behind those actions. You have cause and reason behind those actions. You don't got cause and reason behind those actions, the whole 9 yards. What are you doing? Are you doing something that's lawful? If you're not doing anything that's lawful, it's automatically tossed. And that opens the door for you to be sued. That's an officer, that's a police officer, peace officer, a judge, anybody that's working in public service. That opens the door under subsection, under U.S. Code, Title 18, U.S. Code 242, deprivation of a right or privilege. The facility's EEO basically deprived the officer when she sent the rebuttal to the state of New York. She breached her, how would you say, her corporate compliance policy of her employer. Also, uh, discrimination laws. Okay, because the officer filed a complaint on the first action of July 17th, and then the second action in retaliation with a probationary assistant deputy director said, don't allow him to go down and park in that area, which the officer was already parking there for 2 years and a month before he even got there. So by the time July rolls around, how long is it now? Let's see. March, let's say April, May, June, July. So it's 2 years and 6 months. No. You have no right to do that. Undersigned contract agreement. Undersigned contract agreement. All right? What's your grounds for breaching that contract? What did the officer do for you to breach that contract? He did nothing. So on what grounds do you have to breach that contract? It's a signed contract agreement. Explain yourself. Now you're doing this action, oh, I can do it because I want to. Really? You're on probation. Are you aware of the employer's rules and regulation, rule number 5.2.1? I mean, what does it say? 5.2.3 to be exact. Which is termination of a probationary by the appointing officer for actions of gross misconduct. Use of the vehicle, right there, is gross misconduct. That's grounds for immediate termination. But you got to hook up. Everybody turned their head and looked the other way. From the appointing officer on down. From the appointing officer on down. Everybody turned their head and looked the other way. This individual did this he did this at least 3 times. He was ruthless with his actions and reckless with his actions amongst that facility. So for each one of you that turned your head and looked the other way, it's not just the labor relations officer that got it. Yeah, they got it. They dipped and went to another facility and got it. All the others must be held accountable, according to Mayor Executive Order number 16. The Human Resources Department already knew about it. The Labor Relations Department already knew about it. But the key fact about this is the the facility's executive director just happened to be the senior vice president, who the president of the organization delegated the powers and responsibility of human resources and labor relations to them. So under Mayor Order 16, if the EEO was to inform the Office of Corporate Compliance Officer, and he was to inform the agency's Department of Investigation, DOI, Commissioner, and Inspector General, who would they report it back to? Guess who? They will report the incident back to the senior vice president who was in charge, who also happens to be the executive director of the facility. There's your conflict of interest right there. We got conflict of interest. We got abuse of authority. All right. We got misconduct. Hold up. Conflict of interest, abuse of authority, misconduct. Isn't that all in Mayoral Executive Order number 16? Where you're obligated to report this corruption or corrupt. It's corrupt. It's abuse of authority. It's misconduct. it's conflict of interest, it's mismanagement. That's all in your neighborhood right there. It's all in your neighborhood. But yet you took and you say, we're gonna get rid of the civil service. You do know where civil service come from, right? Don't know? Comes from China. Yeah, it comes from China under the merit system. Yeah, under the merit system. That's why we take a test to get the job. And then go through the necessary steps of investigation and yada, yada, yada. So if you're going to breach the civil service system, why are you even taking the test? Why are you even paying for it to take the test? How many civil servants have you done this to? That's the key. The mere fact that you did it to one and you was exposing your actions and what you did to one and show the possibilities of your gross negligence and abuse of authority brings about the question. It goes all the way up to the ladder to the fact of those that's involved, it's all actions of ultravirus where it went beyond their powers because they abused their authority and they were supposed to stop, but they continue to do so. So that falls under ultravirus. It goes to the integrity of all involved, especially the administrative law judge, especially the representing union grievance, the grievance coordinator, who was a litigation attorney, and the opposing lawyer, and who they both of them signs their name Esquire. So you are in violation of several laws here. There's so many laws that was broken in this, and you're gonna continue with it. Well, he's a dummy. He doesn't know. Really. It's just reading. All you got to do is read. Look how these kids got their books now. Look how they books come. You talk about, this, and that. You get a library. Right here. See my chocolate angel? You get a library right there. PDF everything. PDF everything. Then highlight it. And read it over and over and over again. So for that individual who was talking that trash, oh, you don't know what you're talking about. There's two sides, baby, two sides. You got to get them on the public side. And once you get them on the public side and how they breach their they sign contract agreements and breach their authority, how they violate their corporate compliance policy, how they broke several laws, then you go on the private side and show how you were injured via a act or a omission, something they failed to do. Which brings it down to fundamental fairness and fundamental rights. And under fundamental rights brings about due process. And they breached the due process before they had taken your life, your liberty, and your property. I do believe civil servant jobs are property. Okay, you just can't terminate them. You got to use due process to get them. So since you violate that due process, guess what happens? Guess what happens? That substantive and substantial right kicks in. That would be a natural living man or woman's right. You can say God, right? But it'd be that natural right. And that natural right vetoes all of that crap you got in the matrix going on. Why? Because what you got in the matrix in the public is man-made. Why do you think you're talking legalese? It's man-made because you don't want them to know. You don't want them to know. All right? You remember they're out there at sea. They're at sea. In currency. So when you go into court, you're going under amity law. How did they violate amity law? How did they violate that? They brought in the documents and put it on there. The supervisor said, "Oh, he wouldn't come back when I said come back." Simple math. Simple math. What time did you call? Oh, I called at 12 o'clock. Says this on the stand. Her document, supporting document, says she called at 11:45. So that would be perjury right there, right? Criminal court, you would be charged. Perjury on the witness stand. See how they push it under the table? We're going to push this. Not a problem. I'm going to use your document. Then we're going to go to the fact that under signed contract agreement, yeah, the officer's not on duty. What? So what? He's there 15 minutes early. He's there getting dressed. He's not. Was he getting dressed? Yeah. He's not on duty. You want him to do something? Yeah. I want him to come back here. So you're giving him an order to do something, right? Yeah. That puts him on the clock. Did you put him on the clock? Did you write it in and sign his timesheet? Even if you did, because I know you didn't, but even if you did, the mere fact of putting him on the clock makes you fall under your guidelines of your employer's department patrol manual. What is that? I think it's page 54. Where you supposed to, paragraph C, where you supposed to send the RMP to retrieve the officer like we always do. As far as transportation, it's your business. And then let's go there. When you go to let's get this real quick. When you go to the agencies or the city's guidelines on use of their vehicles, you say, oh, he got a vehicle, he can use his vehicle. The city says, we strongly disapprove of you using your motor vehicle for personal. It's right there. Use of personal vehicles. The city, what's this? The city strongly discourage the use of personal vehicles to perform city business. Why? You're not covered. Get into an accident, you're not covered. You're not covered. Any questions? You could PDF that. So right now, under Rule 60, right? Oath Court and their corporation has to do a corrective and preventive action because everything y'all did was fraudulent. Why? Because you have that case under case law on the record with fraud and you've been exposed. Everybody's running for cover, trying to retire. A few people has been separated. There's others left. They got to get the same magic. But, like I said, you got to use what they use against you back against them and hold them accountable for their actions, under their oath of office. These people took an oath, just like you took an oath. You took an oath, right? You had to sign that little paper to get that job, right? They did too, right? They obligated just as well as you. As you were, they obligated. They failed to do what they were supposed to do, not a problem. Hold them accountable. And on that note, it's beautiful out. I'm going to have to put this up for that individual. Here's the difference. Think about all the people that you put out illegally. And think about the fact that they all could possibly be studying law. Like I do. And then taking all your documents that you use against them and not use it back against you. Boom. On that note, I'm out. Peace and blessings to you. Enjoy.